In 2019, so this is pre-COVID, we conducted an international survey asking users, only users of international dispute resolution, how they made decisions about what mechanism they used, whether it was mediation, arbitration, litigation, or hybrid mechanisms. Now, there are some surprises and some things that aren't surprises. Here's just a snapshot. The top 3 factors in choosing your dispute resolution mechanism: enforceability, impartiality, and cost. Drill down a little bit further, the lawyers, the external lawyers, for them, enforceability was the most important factor, not a question. But for client users, and by that I mean corporate decision makers and in-house counsel, impartiality was the most important factor. Now, it's not that enforceability wasn't important at all, but what clients are really looking for is a wise and trusted neutral third party to conduct whatever process they consider to be suitable. So, what does this mean for the convention? Arbitration is by far remains the process of choice for international dispute resolution. Litigation is second, according to this survey, and mediation and hybrid dispute resolution procedures third. But if you combine the findings, the rate of use of mediation internationally and hybrids, including mediation internationally, what you find is the use of mediation is already much more than many of us think for cross-border disputes, and it equals the use of international litigation. People are using, though, the hybrid form when in particular their lawyers, quite reasonably, are worried about enforcement problems, right, or potential lack of compliance. And of course, in an international setting, the risks are higher, and this year we've certainly seen that play out with the World Health pandemic. And this makes the Singapore Convention particularly interesting because not only does it promise enforceability and does it complete the international dispute resolution landscape in the way that this visual shows, but it also serves to raise the credibility, the visibility, and the legitimacy of mediation as a standalone cross-border commercial dispute resolution procedure, not just one that you can throw in and mix with mainstream procedures such as litigation or arbitration. And that is fine, that is good to do. I'm not suggesting there's anything wrong with that, right? But the convention is supporting standalone mediation in a way that users say is something they want and need. And this slide really just shows, I think we're all familiar with the New York Convention. The Singapore Convention is what I'm talking about. And of course, just last year, we have the Hague Convention on Foreign Judgments, which deals with litigated outcomes. And both the Singapore and the Hague Convention still have a way to go, but you can see where the international dispute resolution landscape is going. And I think it's important to think about mediation, not just in a silo, but in this ecosystem or in this broader framework. So what happens now? 7 hours or 7 hours and a half after the conventions come into force. Are people going to start mediating internationally more than they did before? No, right? What we need is a framework for a mediation ecosystem, and we need that in a critical number of countries. The convention is one absolutely critical part of this. I've got a list of 10 factors. I'm not going to go through all of them. Number 10 you can't read probably, but I think I remember what it is. I want to highlight number 7, right, which is about courts and the role of judiciary. But let me just, if I have time, which I think I do, just run through the 10. The moderator will tell me if I'm in trouble. So I think it's important to make sure that we have a sort of a cross-border, that our law on cross-border mediation and our law on domestic mediation is congruent or harmonized. It doesn't have to be identical. But when we're building a cross-border international mediation space, jurisdiction, right, a mediation-friendly jurisdiction, we want to encourage international disputes to come to our jurisdiction. And we don't want to encourage, for example, satellite litigation about, oh, is this, does this come under domestic law or does this come under international mediation law, particularly when in complex matters you may have elements of both. Of course, mediation infrastructure, physical and increasingly technological infrastructure, is enforceable so that there is not only quality of infrastructure, but also people have access easily. Mediators in cross-border matters, you need not just local, recognized, qualified and skilled mediators, but also people want choice. And I think increasingly you'll see many mediation centers recognizing appropriately qualified and experienced foreigners as well. That will increase. Now, the Singapore Convention deals with number 4, the enforceability of international mediated settlement agreements. It does not deal with the enforceability of mediation clauses or mediation agreements, the front end, right? So there need to be clear laws about that as well. Confidentiality is another very important part. And I know India, for example, has laws and also case law dealing with many of these other important aspects of mediation law. Number 6, what's the impact of the commencement of mediation on litigation limitation periods? This is a really important point for civil law countries in particular. Most common law countries leave it to practitioners and courts to deal with in their own way. But again, if you're really working across legal systems, it may be something to think about. My main point that I really want to emphasize is that no matter how fantastic this convention might be, right, it's not going to be worth very much unless courts around the world know how to use it and what to do with a mediated settlement agreement when they see that. So essentially the convention says if you have a piece of paper or even an exchange of emails which amounts to a settlement agreement, and if you can prove, for example, by a document signed by a mediation institution or a mediator, that this agreement came from a mediation, that's all you need for direct enforcement or recognition. Now, there's going to be, of course, disputes about whether, all sorts of aspects. And again, I can't go into that now. The same way as there's been, as there is in domestic settings, and the same way as there has been for international arbitration. There's already a considerable body of mediation case law in many countries that can be relied upon, and all of any, I think, ambiguities or uncertainties can be ironed out, and that's nothing that I'm fearful of. But I think what is important is that jurisdictions where courts have had much more exposure to mediation will do better in recognizing and being able to enforce these new type of legal instruments, right? I mean, the international mediated settlement agreement under this convention, it's giving these documents a new type of legal status in international law. I've got a few points about regulatory incentives for advisors, connecting mediation with litigation and arbitration, but I suspect my time is up. I would just, seeing I had cross-culture though in the topic, I would just say I think what we're going to see is an era of the flowering, not so much of, I mean, I think we see mediation being used among cultures, but I think we're going to see a flowering of mediation cultures, right? An increasing diversity in mediation practice, or rather an increasing acceptance of that. And I think if that can be a good thing, and I think the challenge for all regulation is going to be how to have robust regulation that can hold this diversity. Because I think the cruelest thing that could happen to mediation is that the regulation crushes the great cross-cultural differences that we bring to the mediation table. Thank you.
Thank you so much, Najda. And we have just been enriched with your knowledge, and I hope next time when we have time, we can have a detail on for the mediations, since there is time constraint. Thank you so much. So our next guest is Gunvanti Subramanian. Gunvanti is an advocate and solicitor, and she has an experience of 20 years in alternate dispute resolution methods. She has conducted many courses, trainings, and mediation workshops for judges, judicial officers, lawyers, doctors, engineers, architects, accountants, Olympic Council of Malaysia, and the Industrial Relation Department. She has trained more than 500 mediators on behalf of Malaysian judiciary. She has also spoken on numerous topics on mediation at different conferences. She drafted the mediation rules, code of conduct, accreditation guidelines, and the draft Mediation Act for the Malaysian Mediation Center, and deliberated on the draft Mediation Act with the Attorney General's office. With her vast experience, she is also teaching LLM students in Malaysia. Today, she will be talking to us and she will share her views on part of drafting of Mediation Legislation Committee in Malaysia and will share her experience. We welcome you, Gunwanti.
Unmute.
Thank you, Nandini, for that introduction. Can you hear me?
Yes.
Right. Yes, thank you very much. A very good afternoon to my esteemed panelists and fellow panelists, and a very good morning or good afternoon to participants who have joined us from all around the world. And before I begin, I would like to thank the organizers for inviting me to present today, and I'm truly honored to do so. Now, my topic is on the Mediation Act in Malaysia, the legislation post-COVID, pre-COVID and post-COVID. So what I'm going to do is, just give me a minute. Right. So the pre-COVID mediation legislation in Malaysia is known as the Mediation Act 2012. Now, this act came into force in 2012 in August, and being part of the mediation committee and part of the team which actually worked on this act, the mediation committee was looking forward to the act as the use of mediation was not very encouraging at the point of time when this act came into force. And the act is important as it was designed to raise awareness of mediation as an effective dispute resolution mechanism for resolving disputes. I've actually had the privilege of personally being involved with discussions and deliberations with the Attorney General's office over a span of 10 years before this act finally came into force. So we were all looking forward to it. And when the act actually came into force, there were raised eyebrows regarding the lack of certain vital provisions in the act, which may have ensured the progress of the use of mediation in the country, which is sadly not the case. Now, if we look at the preamble of the act, it says that the intent, it actually sets out the intention of the legislature which says that it is designed to promote and encourage mediation as a method of alternative dispute resolution for parties to settle their disputes in a speedy and cost-effective manner. Now, the Mediation Act is applicable to mediators who conduct mediation in various institutions and private mediators. Now, in private institutions, one of the institutions is the Malaysian Mediation Center, of which I am a accredited and paneled mediator on that panel. And we have also the Asian International Arbitration Center, the Construction Industry Board, and the Securities Industry Dispute Resolution Center, just to name a few. And for private mediators who conduct ad hoc mediation. So this act specifically excludes court-annexed mediation. As such, members of the judiciary and judicial officers and court-certified mediators are not bound by this act. And the act also excludes mediation conducted at the Legal Aid Department, which primarily mediates family disputes. And further, instead of identifying and listing categories of disputes which may be mediated, the Act provides a schedule of category of cases which cannot be mediated. And these are some of the categories of cases which cannot be mediated. I will not go through the whole list. Some of it is like injunctions and prerogative writs, land acquisition, native court matters. So by way of comparison, in court annex mediation, when it was introduced by a practice direction in 2010, the courts actually categorize the list of cases which were suitable for mediation. So this is the complete opposite. And some of the cases which the courts have listed as being suitable for mediation is firstly the personal injury claims for damages, defamation, matrimonial disputes, contractual disputes, commercial disputes, and intellectual property disputes. So moving on, I will not, the Act is a very simple Act actually, it only has 20 provisions, but I would like to highlight the drawbacks of the Mediation Act, which in my view is a setback for the mediation community in Malaysia. And I would like to firstly focus on Section 4, subsection 2 of the Act. Now, one of the main drawbacks is this particular provision, because it says and it provides that mediation can be, firstly, it says mediation can be initiated before commencing any civil action in court or arbitral proceedings. However, the legislature chose not to mandate mediation for fear of taking away the voluntary nature of mediation. Now, in my view, this is a misconception of the principle of voluntariness in mediation, because Section 2 provides, 4 subsection 2 provides that the commencement of mediation under the Act shall not operate as a stay of court or arbitration proceedings. So what this means is that even if parties expressly agree contractually to mediate their disputes before commencing a court action or arbitration, this clause in the parties' contract will be rendered nugatory if one of the parties chooses not to mediate. So this provision, in my view, should be amended to provide for at least a discretionary or mandatory stay of court proceedings or reference to arbitration where there exists a mediation agreement between parties. This would be similar to Section 8 of the Singapore Mediation Act and provisions of the Arbitration Act in Malaysia 2005. So this is one of the drawbacks. The other drawback is Section 14.1. I think Nadia spoke about the enforcement of mediated settlement agreements. Now, unfortunately, although the Mediation Act in Malaysia provides that the settlement agreement is a binding agreement, and if the process has already commenced in court, then a mediated settlement agreement can be converted to a consent judgment of the court. However, if the mediated settlement agreement is outside the purview of the courts, that means it has not, it is done privately or outside elsewhere, then that mediated settlement agreement cannot be enforced as a judgment or order of the court. So this is quite problematic, because if one party reneges on the terms agreed upon by parties at mediation, although the same is binding like a contract, it will be difficult for the parties to enforce the settlement agreement, because they would then have to file a civil suit action in court and obtain judgment first before enforcing the same. So this is what I think Nadia was speaking earlier on about that the most important factor, according to the survey which was conducted, was that enforceability is the most attractive reason why parties opt for mediation. And this sadly is one of the drawbacks of the Malaysian Mediation Act. Just very quickly to state that, however, in the court annexed mediation program in Malaysia, it has taken off in a very big way, although they do not have a statutory framework compared to the private mediation conducted outside. And the judiciary has introduced mediation by way of issuing a practice direction in 2010 and subsequently in 2016 to promote mediation. And what they have done is they have set up mediation centers in all the different states, and the Kuala Lumpur Court Mediation Center was the pilot program where they had this. And it's conducted by court officials, judges, magistrates, and registrars. And they have a total of about 88 certified mediators in the country, in the courts. And I was also informed that post-COVID, what has happened in Malaysia is, this is very current. They have also commenced online mediation for the first time in the courts in Malaysia, post-COVID. And these are some of the statistics, very interesting. High Court, we have 500, and this is for 2019, 554 cases, and 242 successfully mediated cases, and in the Sessions Court, 2525, and the success rate of 1937, and so on and so forth. I have to move on because I just like to cover the post-COVID legislation, which has been introduced in this country on the 28th of August this year. Now, this act is the COVID-19 Act 2020, is known as the Temporary Measures for Reducing the Impact of Coronavirus Disease 2019. Now, this act temporarily suspends the non-performance of contractual obligations in several sectors pursuant to the schedule set out therein due to effects of COVID-19 in Malaysia. So basically, a moratorium has been granted for parties who have contractual obligations to defer their contractual obligations from 18th of March 2020 to the 31st of December this year. However, the operational period for this can actually be increased to 2 years by the minister. And some of the suspension and expansion statutory obligations, for instance, the Insolvency Act, the Consumer Protection Act, Distress Act, and various other acts, right, have been suspended temporarily. And what this means, very importantly as well, is in Section 12, where the extension of limitation period expiring during the period of 18th of March 2020, that is when the government enforced the movement control order. So it's extended to the 31st of August this year. And Section 7 is a very important section here because it suspends the performance of contractual obligations under certain categories of contract specified in the schedule from 18th of March to the 31st of December this year. And some of the contracts which have been suspended are, for instance, construction work contracts, construction consultancy and related to supply of construction material, performance bond granted to construction contract, professional services contract, lease or tenancy of non-residential immovable property, and so on and so forth. So it also covers other contracts like wedding contracts for venues, accommodations, etc. Tourism contracts as well. So basically, I would like to move on very quickly, because I think my time is coming up, to the mediation provision in the COVID-19 Act 2020. Now, this section provides that disputes arising in respect of any inability of any party to perform any contractual obligation arising from the categories of contracts specified in the schedule, which we referred to earlier, may be settled by mediation. So once again, mediation is introduced, but unfortunately, it is not mandatory. It's not mandated under the Act. It's still voluntary. But this provision should be welcomed by the mediation community in Malaysia, as this is very historical, because this is the first piece of legislation which gives recognition to mediation for parties to encourage them to resolve their disputes via mediation. And Section 9.2 provides that the minister is empowered to determine the mediation process, the appointment of the mediator, the role of the mediator, the conduct of the mediation, and the conclusion of the mediation. And unfortunately, Section 9.3, although it says that the agreement has to be in writing, and 9.4 says it's binding on the parties, this is similarly worded to the Mediation Act, which I spoke about earlier. And unfortunately, this is also another drawback for mediation in respect of the COVID-19 Act 2020, because again, we are facing the problem of enforceability. So my view is that it is going to be difficult. I've been told that the minister who is in charge of this, which is the law minister, is actually setting up a mediation center to deal with COVID-19 cases. So it has not been set up as yet. So this center, which after it's set up, it's primarily supposed to conduct mediation. So with that, I believe my time is up, Nandini. So no doubt that, yes, so no doubt that, mediation looks like it's very promising. This act seems promising to move mediation forward in this country. So let's see where this goes. And with that, I would say thank you very much again to the organizers for having invited me to speak on this topic. Thank you.
Thank you very much, Gunavanti Subramaniam. And I am really delighted to hear that your country is so swift in drafting post-COVID legislation, though there are certain hiccups also there. And another thing which you said, that even intellectual property is also added in your mediation practice, whereas in our country we are still struggling. It's not the comparison, but we are also doing very best of us, and we are thinking about adding criminal cases also in the mediation purview. So thank you very much for your views. Thank you so much.
Welcome.
Thank you. Our next guest today is Justice Joyce Allowed. Justice Allowed is a retired judge, and upon her retirement in the year 2018 from the bench, she successfully moved her legal profession towards mediation profession. She is a certified mediator of International Mediation Institute. She is also accredited mediator for Center for Effective Dispute Resolution Center, London, UK. She is a member of Chartered Institute of Arbitration, London, and the Kenya branch, the International Council of Commercial Arbitration, Peace Place, The Hague, Nairobi Center for International Arbitration, and African Arbitration Association. She conducts mediation under the High Court Annex Mediation Program, Kenya. She is an accredited trainer for Foundation of Mediation Skills of the Smethford University Dispute Resolution Center. She has recently been appointed a board member of Mediators Beyond Borders International. She is also chair of the advisory committee of the newly formed Africa-Asia Mediation Association. She is a recipient of several international and national awards. Today, Justice Joyce Allowed will be sharing her view and thoughts for mediation at workplace. We welcome you, Justice Allowed.
Thank you. Thank you very much for inviting me to this webinar. I'm here speaking from Nairobi, Kenya. That's Africa. So I'm glad that almost all continents are represented. Thank you very much. Now, yes, well, maybe not all, but Africa is a large continent, so I'm here. Thank you very much. I was asked to talk about mediation of disputes at the workplace. Now, modern workplaces are complex, really complex, and comprise people from diverse backgrounds who have different opinions, different values, different expectations. And over and above that, their employees are expected to achieve so much, and sometimes with very little. So it's no wonder that differences and disputes arise at the workplace, much more today than before. Now, there are several ways of resolving disputes, as the previous speakers have gone through this. And my topic is particularly mediation, so I will stick to that. Now, I believe that mediation they've also said what mediation is, and I'll just say that it's an alternative dispute resolution, ADR mechanism. It is voluntary, it's informal, and confidential. It takes place with the consent of all the parties involved. And mind you, I'm talking about a workplace. Mediation is usually conducted by a trained, and I always like to emphasize a trained, neutral third party, because a trained person has got the skills, and those are the skills that you need in mediation. A trained, neutral third party who assists the parties to work towards a resolution of a dispute or a difference, with the parties remaining in control of the decision to settle. The mediator would remain in control of the process, the mediation process, and that's why a mediator needs to be a trained person. Now, what is workplace mediation, really? There are several answers, but I would say that it's a process meant to improve workplace relationships in case there has been a disagreement or misunderstanding that is leading to a breakdown in working relationship. We are talking about an organization, a company, large or big. Workplace mediation is conducted on the basis that both parties want to achieve a mutually agreeable outcome and solution. A successful mediation should lead to both parties feeling that the outcome was fair and reasonable under the circumstances. I think for me, for the time that I've been conducting mediations after coming from the bench, to me, what is so important in workplace mediation is the power imbalance. And the mediator has to be conscious of the power imbalance. It could be supervisor, supervisee, could be a general manager and a fairly junior person in the company. So power imbalance, a mediator has to take care of it. And there are so many things that bring conflicts or disagreements at work. It could be problems between employees, could be performance issues. You're just not performing, or my boss says I'm not performing and I'm doing my best. Could be harassment complaints, including sexual harassment sometimes, I'm afraid. It could be termination. Mediation can offer an opportunity for a peaceful parting and allay employers' worries of potential litigation. It could be all sorts of things, because these are people working in one company, in one organization. So why mediation in the workplace? Because it's confidential, and disputants get to air their differences without the entire company knowing what's going on. A neutral outside mediator is unconnected with this company, but some companies or organizations prefer to train their own persons to conduct mediations. By the time that 2018 March, by the time I was leaving the International Criminal Court after serving my full term of 9 years, the court started a system whereby it was training senior staff as mediators, so that they could conduct workplace mediations. That touched on staff and not judges or prosecutor. Those are referred to as elected officials. So that could work also, because they had started working. Now, mediation also gives disputants a safe, neutral setting to air their grievances. Those of you who are mediators, and I believe most of you are mediators, you know what that means. I never really start a mediation process until I have a box of tissue papers in front of me, because ever so often I get people break down. In fact, the first time when normally you would think it's the women who break down, but when the first time when a husband, it was a family matter. When a husband broke down in front of me, I was like, okay, I have to use my skills, because you think it's the women. Everybody breaks down at some point. Mediators can deal with workplace disputes without involving other people, and sometimes disputes escalate, and that's why So I'll just give very stage 1, stage 2, stage 3. Basically, this is what I use for workplace mediations. So first of all, the decision to whether to mediate or not will have to be made within the HR department or HR or senior person, because the two people are employees of this company or this organization. So he will have to talk to the two people involved, find out what the issues are, find out how it started, and so forth. And normally it's advisable that he talks to them at different times, not together, because of this issue of power imbalance is so important in workplace mediation, because the junior staff or somebody who is slightly junior would always feel threatened and not sure whether they can sit at the same table with the manager or senior manager or general manager. So HR would normally meet the two people differently, and of course tell them this is a voluntary process, and we are just selling it out to you, should you. So when the parties agree, then the party that complained, and I'd like to refer to this party as a complainant, will then be requested to confirm his or her willingness to take part in mediation by filing a referral form. Once that referral form is signed, the HR will then select a mediator. If that company or that organization does not have its own mediators, and most organizations really don't, but they are moving towards that. Now, upon referral, as a mediator, I would then make contact with these parties. Normally, you'd make a phone contact, introduce yourself to the complainant. You are calling them at different times. You haven't put them together yet. Introduce yourself, tell you have been requested to mediate over the matter, tell me what it is about, I will explain my role as a mediator, answer any questions that the party has, and then I'll do the same with the manager. Call also the manager and do the same. And then individual meeting. Before it was face-to-face, but with COVID around the corner and around everywhere, I suppose now we have to meet differently. Before it was face-to-face, then I would meet the parties at different times, trying to, I would then acknowledge the feelings, because when you meet face-to-face and this is the complainant and you are the mediator, this is the complainant, and this is where a lot of employees just break down. A lot of complainants just break down, say things like, he is the boss, he is so senior, and he's doing this and this, and what am I supposed to do? I'm going to lose my job. So this is the stage when you build trust and develop rapport with the complainant before you reach the manager. You tell the mediation process, repeat it to the, this is how the mediation works. We have some ground rules. These are the ground rules, confidentiality. Do you want to add any ground rules that you feel should make part of this? Because there's nothing really formal in mediation. You develop procedures, rules as you go along. Then normally I would have about 2 meetings with both parties separately, because then I would be preparing them and telling them about the joint meeting that we are going to have, telling them that both of you will now be in the same room, at the same table with me as the mediator, with any other mediator. And the purpose will be to identify areas of concern and begin to explore the issues with the parties, promoting open and honest communication. This is where the mediator skills, use your skills as a mediator, and because these people, you've brought them together for the first time, manager, clerk, or whatever, you're bringing them together for the first time. And you have spent time to reassure them. And of course, the ground rules, confidentiality, nobody else is in this room, just the three of us. This is not going to come out. And mediation is both confidential and without prejudice, because I cannot be called upon should the two of you not come to a resolution and the matter goes elsewhere. I cannot be asked to divulge what happened in these sessions. Courtesy, be courteous to one another, respectful communication, all the ground rules that you know about on that. So that listen actively. This is where the mediator must use the skills, and that is why I always stress that trained, neutral, third party. Then take them through. Sometimes the one party might say, "Can I see you separately without the other party?" Or you, as a mediator, you can find it necessary to look to meet them separately. This is the exploration stage. And what are you exploring? The mediator would be exploring with the party what is underneath the surface. What is it that has brought this? How are things? How did it start? Where is it? At what stage are you in this in the disagreement? Where do you expect to go? What do you expect? How do you see things moving? After this, there could be another joint session, or and should the parties hopefully arrive at a resolution of their own with your assistance, then this must be reduced into writing and signed by both parties. And then there must be closure to this mediation. There's no set method of how you close the mediation, but there must be a closure to it. And then evaluation. These parties that have appeared before you, that you have assisted, they are going to evaluate you as a mediator. They are going to say whether you are a safe pair of hands, or, how, right from the beginning when the process started, they will evaluate you. And these evaluation forms are confidential, and normally they are kept with the human resources or somewhere in that company, but they are confidential documents. Now, coming from Africa, is mediation a process that is new, a mechanism that is new? I would say no. In Africa, we have had a history of community mediation, and I believe other countries too have had such history.
Yes, we do have.
Thank you. But it was informal. I remember years back when 2005, when I established the family division in the High Court of Kenya, I later on discovered that what I used to do was actually mediation, because there was no piece of legislation there was. But I would, those many years back, I would ask the lawyers that, could you just step back and let me talk to the parties one by one? Could you leave the room? At first, of course, lawyers would reject and would say no. Then I would say this, then they would say, okay. So I didn't realize that later on that was actually part of mediation. I didn't train as a mediator until I was at The Hague. So that time was long before my time as a mediator. So Africa, we have always had informal mediation going on, particularly amongst our communities. It still does go on here in Kenya and many other countries. What has happened today is that mediation seems to have somehow been formalized, in that some countries have mediation acts, pieces of law, of legislation, We haven't managed to put ours together yet here in Kenya. It's still there are two bills. One is in the Senate, one is in the Parliament. None of them have been passed and into law. But in Kenya, it is the current constitution, the Constitution 210, that came, an article in it, 159(2)(c), that's mandated the courts to use ADR, and it listed all the forms of ADR, including mediation. And that is what the judiciary took up, set up a pilot project after amending the relevant legislation, which was the Civil Procedure Act, and then formed a committee and brought in a pilot project. And that pilot project ran for a year, and thereafter it has now become a permanent program in the Kenyan judiciary. It's the same in Uganda, I think it's the same in South Africa and in several other African countries. So mediation, the community mediation still goes on, but mediation is today much more structured, in my view, than before. Though I have been a judge for such a long time, I believe that mediation works. I managed to take off my judgeship hat, and today I enjoy helping the parties to have a conversation, and eventually I remind them that it is the resolution that you're going to come to will be one that both of you can live with. I cannot advise you, but I'm assisting you in your conversation. I believe my time is up, and thank you very much for allowing me to talk on this subject. I'll be able to answer any questions should there be time for questions. Thank you very much from Africa.
Thank you very much, Justice Joyce Alauch, and enlightening us about the mediation process at workplace. And also big congratulations to you that after retiring from judgeship, you're taking mediation as your passion and you're helping the community at large. Really creditable on your part. Thank you so much.
Thank you.
Our next esteemed speaker is Rebecca Clark. She's listed as leading mediator in the Legal 500 and described as a rising star of the mediation profession. Rebecca is a full-time commercial mediator at In Place of Strife in the UK, with a unique range and depth of commercial mediation experience. Rebecca is particularly renowned for both her financial services expertise and for dispute involving SMEs, particularly family business. Before becoming a full-time mediator, Rebecca was head of a litigation at a major financial institution, during which time she was awarded Legal Counsel of the Year 2013, partially as a result of a novel approach to resolving classes of disputes by mediation. Prior to working in-house, Rebecca set up and managed her own retail business from scratch, and so has substantial business and accounting experience, which she can draw upon in her mediation practice, enabling her to understand and emphasize with the commercial issues faced by SMEs in a dispute scenario, often acknowledged by commercial parties during mediation sessions also. She has a very goodwill, I must say. She has also worked as a solicitor advocate in a large international law firm. Today, Rebecca will be sharing her experience of commercial mediation in her country. Rebecca, we welcome you.
Thank you very much. I'm delighted to be invited to speak today about commercial mediation, particularly in the context of the COVID pandemic. It's not going to surprise anyone when I say that the COVID pandemic has caused an increase in disputes across the world and across the entire spectrum of economic activity. Commercial parties have been unable to comply with their contractual obligations, whether that's to perform their part of a contract on time or in the manner intended, or to pay for it. one party's failure to perform can obviously have knock-on effects, causing others to find themselves in default too, and therefore in a dispute. And some of these disputes will be critically important for the survival of a project or the livelihood of those involved, and some will be extremely urgent. Parties in these situations will have contractual rights which can be enforced by adjudication, such as litigation or arbitration. However, I think, as we all know, these processes take time and they take money. I don't know what the position is around the world. I'd be really interested in everyone's experiences, but I know that in the UK, the commercial courts were under immense pressure even before the COVID pandemic. Despite a move to remote working, the courts are just not in a position to swiftly absorb and resolve the number of commercial disputes arising. Indeed, the Lord Chief Justice in the UK has made it clear that the court system will never again operate as it did before the pandemic, and has encouraged the use of alternative dispute resolution to reduce the pressure on courts and keep access to justice open to those who need it. And he said, "I would urge all, before agreeing to adjourn any hearing, to use the available time to explore with the parties the possibility for compromise." And Lord Neuberger, who is a former president of the Supreme Court, has appeared on national radio encouraging people to consider mediation. Now, it's certainly true that a mediation can be arranged far more quickly than a court hearing, even where there are multiple parties. We're talking days or weeks rather than months or years. And this can obviously be critical in a business context where parties need a dispute to be resolved as soon as is reasonably practical. It's also true that litigation or arbitral proceedings are expensive. They're a drain on cash flow, but also on management time. And in my experience, parties unaccustomed to legal proceedings hugely underestimate the cost of the diversion of management time, which is obviously unwelcome at any time, but particularly at the moment. Holding mediations on Zoom rather than face-to-face has, on the whole, in my experience, made them both cheaper and quicker to set up. And when we can all travel again, it'll be interesting to see whether parties will want to spend a day traveling to a mediation and a day back again, when they can save time and cost by attending remotely from their home locations. And that's quite aside from the environmental considerations. But as I hope we all know, mediation offers more advantages than simply cost or time savings. And I think it's those advantages which make mediation particularly appropriate in this new world. So what are they? Firstly, it can be used to avoid litigation in the first place. You don't have to have issued formal legal proceedings to mediate. And because of this, it can be used at many different stages of dispute management. So yes, it can be used in a traditional issued legal case, but it can be very effective as a crisis management tool too. Mediation allows parties a safe and legally protected environment to explore very practical solutions to a problem. It's confidential and it's without prejudice, which gives parties the freedoms to explore options or perhaps make concessions for the purposes of exploring options without blotting their copybook if they wind up in court. And the range of solutions is huge. Perhaps one party can be given more time to perform its obligations or to pay. Perhaps other parties can be brought in to perform certain functions, or something could be outsourced. One party might be prepared to accept a lower payment if it means the project can be saved. I mean, consider the example of multiple parties who have to work together on a construction project. These sorts of agreed practical solutions can save a project at a very early stage. And they're not the sort of solutions available to judges in courts, where the outcome tends to be win or lose. Where mediation is used in the early life of a dispute, it can salvage or even strengthen relationships between parties. And this is really important where you have habitual contractual parties, or where parties operate in the same market, or where one's business is dependent on the survival of the other. But I think that the main advantage of mediation is the opportunity it gives a party to manage risk. When you start legal proceedings, control over the process moves from a party to the legal professionals. And your legal team will take you through a number of stages to prepare, and you may wind up at a trial where you're asked a series of questions, but at which you have no opportunity to personally speak. And then the final decision on the relevant facts or law is handed to a judge. And any litigator will tell you that regardless of how strong one may feel the legal position is, there is a risk that a judge hearing a case will prefer a different interpretation or impose a solution that doesn't work for you, or a witness won't perform as well as you anticipate. And in that way, both control over the process and the outcome is lost. Mediation, on the other hand, hands the process of risk management back to the disputing party. It allows that party to consider the risk of settling a dispute versus the risk of not, whether that risk is legal or commercial, whether it relies on the strength of a legal position, the risk of running out of money to fund it, the diversion of management time from core business, damage to reputation, or an unacceptable solution. Each party will have different risks, but mediation allows the party to decide what their own appetite for risk is and to make their own decisions accordingly. And I think that in times where COVID has caused such worldwide unpredictability, that there is some considerable appeal in being able to take back some element of control. As Nandini has said, I became a mediator because of my experience of mediation as head of litigation at a bank. And when I joined, it's fair to say mediation was viewed with some scepticism by those above me, primarily, I think, because it involved compromise, and it was thought that this was a sign of weakness. But I persuaded those mandating that mediation actually gave us back control. It gave us the chance to take a risk-based approach to a number of different types of claims, which after all were assets of the business. And we could look at a case, assess our exposure to risk on legal and economic factors, and then give a value to that asset. And if we could achieve a settlement within a range of that value at mediation, we would settle. And if not, we wouldn't. But it also gave us the opportunity to lump together large numbers of cases. For example, all cases involving a particular insurer, a particular developer, a particular third party. And this opened up huge economies of scale, and also meant that once one of those big amalgamations was resolved at mediation, we got rid of a huge number of cases. And I can see this sort of approach having real merit in the context of COVID insurer-based commercial claims. So, in my opinion, it's undoubtedly the case that mediation holds some very real advantages over adjudication in the context of resolving disputes during and post-COVID. Surprisingly, even the UK government has commented. The Cabinet Office has issued guidance to both public authorities and private enterprise on responsible contractual behaviour post-COVID. Stating that the government strongly encourages parties to seek to resolve any emerging contractual issues responsibly through negotiation, mediation, or other forms of fast-track dispute resolution before these escalate into formal intractable disputes. And the guidance encourages requesting and responding to requests for mediation. And it's in the context of 3 recent judgments in the UK from 2020 from the courts, which have emphasised that a refusal to mediate, so even prior to this pandemic, would result in financial penalties and laying down markers for more stringent times ahead. And the Law Society has commented that these cases have provided a very real economic incentive for parties to say yes to mediation, because the price of saying no has become rather costly. So, will the COVID pandemic herald a golden age of mediation? I suspect I'm biased, or I accept I'm biased, but I truly hope so. I think more than any time before, there's a real political and judicial will to bring about a new way of doing things. And this, combined with the economic climate we find ourselves in, might just result in a watershed moment for mediation. I think at its heart, mediation is a way to manage difficult conversations. And unfortunately, we are all having lots of those at the moment. Thank you. That's all I wanted to say. Nandini, I'll hand back to you.
Thank you so much, Rebecca. And in this limited time, you have explained the commercial mediation aspect so seamlessly, though it is a very difficult and complex process. Thank you so much.
Thank you.
Thank you. So our next esteemed guest today and an established mediator and speaker is Ms. Her practices focus basically on commercial arbitration and mediation. She has been recognized as a pioneer for ADR legislative reforms and related capacity building in the Caribbean. Most notably, Ms. Cooper has been appointed as an arbitrator for several international centers for settlement of investment dispute annulment proceedings. In addition, she is listed on numerous panels of international arbitration institutes. Ms. Cooper Russell is managing partner at Russell and Cooper, Cabinet Caribbean at the Bahamas, and door tenant at 3 Hare Court in London, UK. She is master of the bench of the Honorable Society of Middle Temple. Ms. Cooper Russell is a fellow of Chartered Institute of Arbitration, founding chair of the Bahamas branch of the Institute of Arbitration, as well as a fellow of the Malaysian Institute of Arbitration. She is a council member of the Commonwealth Lawyers Association, responsible for the Caribbean and the Americas. Ms. Cooper is part of the process of bringing legislation on mediation in Bahamas, and I have been told that in Caribbean countries, women dominate. So she is going to share her experience with her. Ma'am, we welcome you.
Thank you very much, Nandina. And indeed, again, it's a pleasure to be here with the esteemed panelists that I have had the honor to be appointed with. Living in a hurricane-prone zone as in the Caribbean, hurricane preparedness during the months of June to November is a normal way of life. Although Caribbeans are never certain 100% if their islands will be hit during the hurricane season, they nonetheless remain in a state of preparedness. Prior to the outbreak of the pandemic, there was absolutely no indicator that prepared us for the massive disruptions that impacted every aspect of our lives. However, as I prepared my presentation to give an overview, a brief overview of our experience in the Bahamas regarding the development of mediation and the mediation legislative infrastructure, it became evident that the charting of mediation post-COVID-19 was foreshadowed when Santan Krishnan became president of the CLA in 2017. During Santan's tenure, while visiting numerous Commonwealth countries, his mission was to advance the effectiveness of mediation. The pre-COVID-19 charting of mediation further advanced by Brian Spears when he took over presidency of the CLA in 2019. Under Brian's leadership, we have seen the CLA playing a key role in promoting the Singapore Convention on Mediation that entered into force today and advocating for the online mediation, particularly during post-COVID-19. Upon my election as council member for the Americas and the Caribbean in 2019, the Executive Council of the CLA quickly endorsed my conception to focus primarily on the development of the legislative framework for mediation in Caribbean jurisdictions. With the collaboration of the Canadian Hub, led by Laurie Polazzi, we decided to implement a pilot project in the Bahamas for mediation legislative reform. In October of 2019, I set about in seeking the assistance of 3 of my colleagues who are highly skilled mediators, retired Justices Ruby Nortage, Kelvin Cunningham, along with Carol Lashley, to participate in an ADR legislative reform working committee. The main mandate for the working committee was to present draft legislative frameworks for alternative dispute resolution mechanisms within a set time period. The next step was to invite key partners who were essential for the successful implementation of the ADR legislative framework, namely the policymakers and key members of the judiciary and the legal profession. We were fortunate to secure the support of the Chief Justice of the Bahamas, Sir Brian Murray, who practiced as a mediator while in private practice. R. C.J. Murray is a keen advocate of mediation and has entrenched provisions for court-appointed mediators in the upcoming new Supreme Court rules. Our second partner to support our initiative was the Bahamas government. The National Economic Development Plan of the Bahamas calls for the Bahamas to become a sophisticated international arbitration mediation hub in the Americas. The ADR Working Committee task, therefore, was in sync with the policymakers' national agenda. Our third partnership was with the Bahamas Bar Association. The full endorsement of our efforts was evidenced by the president of the Bahamas Bar Association, Khalil Parker, who pledged the support of the committee by approving for the chair of the association's arbitration ADR to participate in the working group. Other stakeholders who joined our working group were the Bahamas branch of the Chartered Institute of Arbitrators and the Chamber of Commerce. Between October 2019 to February 2020, the ADR Working Committee met in subcommittees to cover international commercial arbitration, adjudication, financial services, and youth arbitration and mediation. Also, our work received technical support from the United Nations Commission on International Trade Law, UNCITRAL, and the Permanent Court of Arbitration, the PCA, for the drafting of the International Commercial Arbitration Bill and mediation, both based on the model law, UNCITRAL model laws. We have at present time the Arbitration Act of 2009, based on the UK Arbitration Act of 1996. But moving towards a more model law jurisdiction will make the Bahamas more user-friendly for end users coming from both civil and common law jurisdictions. In March of this year, when the explosion of the pandemic disrupted the global economy, the ADR working committees were already in full gear to chart the legislative infrastructure for mediation because the groundwork was previously laid in pre-COVID. During the emergency orders lockdowns, the working group realized that it was more important than ever to complete its task, especially as parties revisited their contracts to see if force majeure provisions could be applied. After bunkering or hunkering down from March to July of this year, we coordinated a training sessions for the Bahamas Judiciary Education Institute over a 2-week period in August. During the sessions, the amended International Commercial Arbitration Bill of 2018 and the Mediation Bill of 2020 were presented to the Chief Justice and members of the judiciary in the Bahamas and other jurisdictions in the Caribbean. Also, presentations from UNCITRAL, represented by Judith Knepper, the PCA, represented by Fidelma Smith, the International Center for the Settlement of Investment Disputes, ICIT, represented by the Secretary General Meg Cannell, the International Council of Commercial Arbitration, ICCA, represented by Professor Marike, along with preeminent international arbitrators, mediators, including Professor Jan Paulsen, Ike Iribe from Nigeria, the Honorable Barry Leon from Canada, and even one of your very own compatriots from India, Anish Wadia, all presented before the judiciary. In concluding, the question is asked, will women in the Caribbean play a pivotal role in advancing mediation post-COVID-19? My response is a resounding yes. Today, women in the Caribbean, who make up the majority within the legal profession, already have assumed a dominant role as mediators in the region. Although there's much to be said about the very disproportionate appointments of women as Queen's Counsel, I believe that post-COVID-19 provides skilled women mediators in the Caribbean an opportunity to excel and export interregional and beyond their skills in mediation that might not be available in the traditional litigation environment. Also, the esteemed professionalism and the hospitable nature, welcoming nature of Caribbean women bring together another dimension to the preservation and objectivity of mediation that makes parties feel good and empowered. These attributes of women mediators from the Caribbean region readily falls within former US President Obama's speech during a leadership conference in Singapore last December, where he mentioned that he is absolutely confident that if every nation on earth were run by women for 2 years, one would see a significant improvement across the board in just about everything. Excuse me. I conclude by saying that given the opportunity for women mediators to resolve the disputes caused by COVID-19, be they commercial or family matters, there is no doubt that they will be able to chart solutions in a post-COVID-19 world. Thank you.
Thank you very much, Martha Cooper. And after listening to you and today's program, the way it is going, more power to women. Thank you very much. So friends, our panelists, they have now given their lectures, and now I welcome Honorable Justice Huma Kohli, Judge, High Court of Delhi. What should I say about her? She is the chairperson of the Legal Aid, Mediation and Conciliation Committee and the Family Courts at Delhi. Apart from performing her official duties as a judge, she takes a keen interest in promoting mediation as an alternate dispute resolution forum, in highlighting the role of judiciary in perseveration of the ecology and environment and the role of family court in resolving family dispute. She has participated and presented papers at several national and international symposiums and conferences on this subject. Today, Madam Kohli will be enlightening us and will share the concept of pre-litigation mediation in civil disputes. We welcome you, ma'am.
Many thanks, Nandini. It has been a pleasure to hear all the panelists speak by turns, and always a pleasure to see the chief guest, Justice Banerjee, on the panel. I look forward to hearing from her and her views too very soon. I must thank the organizers, the Commonwealth Lawyers Association, which has collaborated with the Supreme Court mediators and the Youth Bar Association of India to give us this platform for discussing and debating and hearing what post-COVID mediation would be all about and what would be the way forward. Just as Justice Joyce was mentioning, that for the African continent, mediation is nothing new. It has been there, ingrained in their society for several years, maybe decades, maybe more than that. That's true for the Asian continent as well. I would say particularly for India. The ADR mechanism has a very deep-rooted presence in the Indian context. A few of the well-known and attractive options of ADR we all know is mediation, it's conciliation, primarily arbitration, negotiations, and settlements through judicial intervention. But I'll give an example that dates back to the ancient Indian times when we had the ancient Indian epic, the Mahabharata, where an example of mediation is that of Lord Krishna, who had donned the mantle of a mediator and had tried to facilitate a settlement between two warring branches of the royal family, the Kauravas and the Pandavas, in the hope of trying to avoid a battle for the throne of the kingdom of Hastinapur. So that is a prime example probably all of us would vouch for. There are several other processes of ADR also that were practiced in the olden days in India in one form or the other. One can talk about the Panchayati system, which dates back to the Vedic days. This system, which involved respectable members of the community to come together and predominantly act as a primary dispute resolution mechanism in the Indian villages, is very well known. Another recent form of ADR has been what we call the People's Court, the Lok Adalat. That's a concept that has been statutorily recognized in the shape of the Legal Services Authority Act, which was in terms of the mandate of Article 39A of the Constitution of India. Then in the year 1992, what we call the Panchayati system was also given a legal status by an amendment to the Constitution of India, the 73rd Amendment. Now, ADR mechanism, as far as the judiciary is concerned, I would say has played a major role in the justice dispensation system in the courts that are overburdened with a huge backlog of pending cases and an ever-increasing number of fresh cases that are filed on a daily basis. Faced with this docket explosion, the ADR mechanism is a favored mode that provides for time-effective and cost-efficient resolution of disputes. So sometime in the early 2000s, our Civil Procedure Code recognized mediation, arbitration, and conciliation as also judicial settlement as are tools where courts could refer matters for settlement. The said process has also been recognized in 2018 through the Commercial Courts Act that was by virtue of an amendment. And there is a chapter on pre-institution mediation and settlement that has been introduced with the idea that before a party institutes any suit in the court, which does not contemplate an urgent interim relief, it must exhaust the pre-institution mediation. So there's a legislative backing to this process. The task of completing the process has been assigned to the Legal Services Authority of a state, and there is a stipulated timeline of 3 months, with another 2 months granted to parties for a settlement with their consent. Now, this settlement, which is arrived at through the pre-institution mediation process under the Act, is given the status of an arbitral award, which means that it is enforceable in law. A settlement arrived at through mediation can be enforced just as an arbitral award can, which is a big plus for mediation and sanctifies it legally and statutorily. We also have the term mediation referred to in the Arbitration and Conciliation Act of our country in Section 30. So it rubs shoulders with conciliation process, and both mediation and conciliation were introduced with the sole object of encouraging settlement of disputes between the parties, whether by mediation or conciliation in the course of the process. Recently, as I understand, Supreme Court has taken an initiative to recommend a model law on mediation to be legislated, which has, on which a committee of experts have given a recommendation to the government, and hopefully it shall be tabled soon. And that itself will then put in place the entire mediation process under one umbrella. Now, coming to the challenges that have been thrown by the COVID pandemic, where it has spread over 220 countries and has impacted millions of people across the world. Many of the countries like ours have remained in a lockdown for several days together. Even now we are in the stage of unlockdown, so to say, unlockdown 1, unlockdown 2, unlockdown 3 on a monthly basis, looking at the scenario. So it is not going to be normal for us for some time, quite obviously. So what has it meant for us? It has meant that we, the courts, have moved from physical hearings to the virtual platform and have been conducting courts virtually for now several months. Just recently, the Delhi High Court has opened very partly for physical hearings. And it's heartening to know that the legal fraternity has been quick in responding, has also backed the virtual hearings, and the number of virtual footfalls are more than the physical ones, even though the courts are physically open. What has it meant for us in the Delhi High Court Mediation and Conciliation Center? Incidentally, this is a court-annexed mediation center. And it is one of those centers which has been doing pre-litigation mediation for the past over a decade. It has meant that we have also moved from the physical mode to the virtual mode and decided to encourage mediation through the online dispute resolution, ODR, the new term. So what is the concept of the pre-litigation mediation? Is the process which was earlier done physically is now being commended to be done virtually. To give an example of the statistics of the pre-litigation mediation in the Delhi High Court Mediation Center, from January to December last year, we had about 440 cases instituted in that process, and about 140 cases were settled out of that. As against that, the regular court-referred mediations were in the range of 2,626 odd. And out of that, about 828 were settled, with another 899 connected matters that were settled, which was a big plus for us. Now, having adopted the ODR method, we had to arrange mediation sessions on a platform of Cisco WebEx. We started with one license, not sure how it would go, and were very pleasantly surprised to see the response we got. we have now acquired 5 licenses. We are conducting sessions about 25 to 30 on an ODR platform on a daily basis. We have involved in this whole process 58 mediators and an equal number of co-mediators to participate and assist in the process. So this process that commenced sometime in June 2020, and by the end of August, we have already received 72 odd cases in pre-litigation. Now, if I give you an example, though the courts were working virtually, obviously we were not working 100%. We couldn't have, the volume of matters being what they are, and the urgent matters were being attended to. We have referred 132 matters in the High Court in this period as court-referred mediations to the Mediation Center. So you will see that the number of pre-litigation mediation has really shot up in this duration. These include the disputes relating to commercial matters, to family disputes, to matters related to properties, to disputes between husband and wife. It's the whole range. And adopting this ODR method has really made a plus for us. Why? Because it has brought the mediation into the homes of the litigants. All the parties need to do is to log into the session from their home, from their office, from any part of the world and participate in the sessions. ODR has therefore in every which way transcended borders and overcome distances. It is also a boon for those who are suffering from comorbidities. And in these pandemic days, everybody is avoiding the need to expose themselves to the infection. And adopting the online process means they can still participate while staying safe in the environments of their homes. For initiating this pre-litigation mediation, we have set up we already had a process which was in place, so the parties could simply email an application to our center, provide the details of the other side, and the process would be sent into motion for a very minimal fee. The center would appoint a mediator or a conciliator to facilitate the settlement, and this SOP has now been tweaked and drawn up for online mediations as well. So now a party must give a consent to participate in the online mediation. It must give a consent to maintain the confidentiality process. And how do we do that? We have an undertaking that pops up on the screen immediately on a party accessing the session. Till the party clicks that and a token of acceptance, the session doesn't commence. At the end of the process, if a settlement is arrived at, the mediator prepares an e-settlement draft that is electronically forwarded to the parties concerned. On their giving consent to the terms of the settlement, the mediator reads aloud the terms to the parties and takes their oral consent first. Thereafter, the settlement deed is drawn up and converted into a PDF format for being emailed to all the parties for their consent. After verifying the contents of the settlement, the final settlement deed is endorsed by the parties through their digital signatures for authentication purposes and emailed back to our center. So at the end of all the parties digitally signing the agreement, the mediator affixes her or his signatures on the final settlement. The center provides one copy to each of the parties and keeps one copy for the record. If it is a court-referred pre-litigation mediation, as in referred through the Commercial Courts Act, which I was just mentioning, makes it mandatory to do pre-litigation mediation in a set of matters, then that settlement agreement is emailed to the concerned authority who's designated under the Act to place it before the concerned court. So this is how the online pre-litigation mediation has been working in the Delhi High Court Mediation Center for the past 3 months, and I must say, quite successfully. I may leave you with a quotation of His Holiness the Dalai Lama. I quote, "The planet does not need more successful people. The planet desperately needs peacemakers, healers, restorers, storytellers, and lovers of all kinds. To my mind, mediators eminently qualify as peacemakers. They qualify as healers of the heart. They qualify as restorers of broken relationships and lovers of mankind. They make a difference to the lives of all those who come in contact with them. And that is what mediation is about. Thank you.
Thank you very much, Justice Huma Kohli. And you have explained to us seamlessly the pre-institutional mediation concept. And not only me, the audience will be so happy to hear that the High Court Mediation Center is bringing mediation at par with arbitration, which will be a very, very welcome move. Thank you so much. Our chief guest today is Honorable Justice Indira Banerjee, Judge, Supreme Court of India. In her tenure in the Honorable Supreme Court of India, Justice Banerjee has authored innumerable landmark decisions which have charted the legal jurisprudence of our country. One of the landmark judgment is Sushila Agarwal versus State of NCT of Delhi, a 5-judges bench clarifying that there is no time limit on when an individual can seek anticipatory bail under Section 438 of the Code of Criminal Procedure. I was trying to find out some judgment on mediation. I could find out one judgment. It's called Dattatreya versus State of Maharashtra. Justice Indira Banerjee authored this judgment as a part of a 3-judges bench and reduced the appellant's death sentence to life imprisonment due to a lack of pre-litigation and mediation. The appellant had been accused of murdering a minor girl. Justice Banerjee emphasized that the accused has received unsatisfactory legal aid, pointing out non-assistance by a social worker and absence of attempts to place on record mitigating circumstances. Further, she observed that the trial court failed to consider the question of reform when imposing the death sentence. There's another judgment of 2020. Justice Indira Banerjee was also part of a 5-judges bench in Indore Development Authority versus Manohar Lal and other that interpreted Section 24 of the Land Acquisition Act 2013, holding that landowners who refuse to accept compensation for land belonging to them that was acquired cannot subsequently seek cancellation of such acquisitions. This was one of the great judgments in the history of Supreme Court. Madam, we welcome you and we are privileged to hear your words of wisdom.
Very good evening to all of you in India.
Good evening, ma'am.
Good day to those abroad, or otherwise hello, which applies at any time of the day. The need to adapt to change is fundamental to justice delivery. Laws, both substantive and procedural, evolve with changing times. Scientific and technological developments, changes in the social system, liberalized ideas, economic advancement usher in changes in the system of delivery of justice. To meet the problems caused by proliferation of cases and pendency of arrears, the Law Commission recommended that the Civil Procedure Code be amended. The Civil Procedure Code was amended in the year 1999 to make provisions for reference to alternate dispute redressal fora of arbitration, mediation, conciliation, etc. But unfortunately, at that point of time, it was opposed by the legal fraternity, and many others. Similarly, technological developments have been very notable in the last couple of decades, and the use of computers has become very, very common. In fact, I still recollect in 2013, I was sent to Singapore to the Civil Services College for a training, 1-week training program in judicial administration. We were taken to courts in Singapore, and we found the courts were completely paperless. The Attorney General used to address the court from his office and not from the courtroom. The interpreter used to interpret from her residence or maybe from her office.
Singapore.
Yet, this seems to have been a kind of mind block to technical upgradation, and also, with the greatest of respect to mediation. Of course, Delhi High Court Mediation Center has indeed done very well. I was also associated with the center when I was chairperson of the Delhi State Legal Services Authority for a short stint of about 7.5 months in 2016-17. Unfortunately, other mediation centers over the country have not had a very good success rate. The first court-associated mediation center was established in 2006. It was associated to the Madras High Court. But unfortunately, the success rate subsequently has not been very good. But of course, Delhi High Court has been doing well, and the mediation center at Bangalore has also had a very good success rate. But this was pre-COVID. Mediation was thought about in the pre-COVID times, and the need to reduce arrears, the need to quicken the delivery of justice, expedite the delivery of justice. These things were thought of for a few decades now. But in the end of 2009, COVID-19 broke out in Wuhan, in China. To deal with the pandemic, Wuhan was closed. Traffic stopped from January 23rd, 2020. Chinese citizens all over the country were required to isolate themselves at home, wear face masks when going out, have their body temperature measured, and be tracked when entering and leaving public places. From late January, the situation worsened and the COVID infection spread all over mainland China. Within 2 months, the number of confirmed cases reached 79,824 in mainland China. This was by the end of February. On 30th March 2020, the World Health Organization declared COVID-19 a pandemic. The US imposed a travel ban on Europe from 1st March. By the end of March, more than 60 countries and regions in the world had successfully declared a state of emergency. In India, a lockdown was declared on or about 28 March. Initially, for 2 or 3 weeks, and it was extended from time to time. By the end of March, more than 60 countries, by the end of June, More than 200 countries and regions around the world were affected by the COVID-19 infection. This created a lot of panic, more perhaps because of the media hype. The outbreak of COVID-19 can be said to be a typical crisis event, creating high levels of uncertainty, creating panic, anxiety, because people were at home, they were watching the media, they were looking at the social media, there were horrifying stories of dead bodies lined up in some countries, the experiences of people who went to the hospitals. Now, in times of highly developed media technologies, the information available on COVID-19 was perhaps even beyond legitimate demand for information. What happened as a result was life practically came to a standstill, partly because of government guidelines and partly because people, out of sheer anxiety and panic, chose to stay at home. In India, we saw a sudden movement of migrant laborers because everything had been stopped all of a sudden, giving rise to diverse kind of problems. As my old colleague and friend Justice Hima Kohli pointed out, the lockdown was lifted in phases. But unfortunately, people are still reluctant to really go out. Malls were shut down for a long time. Hotels were not in operation. There are certain areas where business has been very badly affected. Let us say tourism is one area. The hospitality business has been very badly affected. Travel, the airlines, we have even heard of pilots and air hostesses being laid off by many airlines. In fact, some of the airlines were even closed down. Now, a new kind of dispute, new kinds of disputes have arisen because of this pandemic. One is people are constrained to stay at home, and that has also given rise to family disputes. It is reported that in some jurisdictions, the rate of filing of divorce petitions have increased. There are issues of maintenance. There are issues of child maintenance, so on and so forth. In many cases, it is found that there have been breaches of contracts, not because of any fault of the parties, but because of the situation. Now, these business disputes can be amicably settled through mediation, because the businessmen would want to carry on their business. The idea is not to get into disputes. Maybe because business came to a standstill, many people were unable to pay rent. This gave rise to tenancy disputes. Many business houses were constrained to decrease their work strength. So this also has given rise to disputes between the employer and employee over termination, over payment of their dues, so on and so forth. Initially, there was a resistance to mediation, as I stated, in many parts of the country for almost 2 decades or so. And over and above that, there was also a feeling that virtual courts should be discontinued and regular courts should be started. This was impractical because distancing is absolutely necessary. Crowding in courtrooms causes spread of the infection. The rooms may have to be sanitized at short intervals, etc. As a matter of fact, as my colleague Justice Hima Kohli pointed out a little while back, that though physical hearing was started in Delhi High Court, the footfall was not much, and lawyers preferred to appear online rather than actually physically appear in court. Today, I saw a news report in the newspapers that about 500 lawyers have written to the Chief Justice of the Delhi High Court to discontinue open court hearing. Similarly, the Supreme Court had also to start open court hearing, and about 1,000 cases were listed for open court hearing. It was decided to list about 1,000 cases, but we did not get very good response from the lawyers, obviously for reasons of health. Now, one thing is certain, this unprecedented situation has made us accept virtual court, and it has also made us accept online resolution of disputes and also online settlement of disputes, because people can get some justice from the safety of their homes. Today, almost everyone has at least a smartphone, at least in this country, almost everyone has it. Initially, there were, of course, some concerns, and I would like to just remind you of the World Press Prize-winning photo of John Stanmeyers in 2014. This was a shot of refugees in Djibouti trying to pick up signals from neighboring Somalia. The photo shows 8 men, all African migrants, on the shore of Djibouti city, silhouetted against a moonlit sky and sea, holding their phones aloft in an attempt to pick up a cell signal from neighboring Somalia. In India also, while holding virtual courts, we did have initial teething problems. There were connectivity issues sometimes. Lawyers were not very familiar with the system, so they had to be kept. We had to keep reminding the lawyers to unmute so that they could be heard. Sometimes they would be pressing the wrong buttons. But today the situation has considerably changed. To be very honest, even the older generation, not very familiar with computers, have now become much more computer savvy than they earlier used to be. So online dispute resolution, whether by adjudication or by mediation and settlement has come to stay. It does not appear that the COVID situation is going to improve very much in the near future. Maybe later on it will. But be that as it may, I think once people accept online mediation, or online adjudication of disputes, online resolution of disputes by mediation, this will come to stay because of the immense convenience. We have seen many mediations get delayed because the other party would not be able to come and physically appear. Today, that is not necessary at all. A person doesn't have to come from abroad, or a person doesn't have to go abroad for mediation. It can be done online. The other day, when we were having a court hearing, Mr. Harish Salve was appearing from London. We have lawyers appearing from Tamil Nadu, Kerala, Bangalore, Calcutta, all kinds of places. Now, there are definite advantages of mediation over adjudication. First of all, it is less informal. It is less formal. It is more informal. It is absolutely voluntary. And it is not a win-win, lose-lose situation. Both the parties, by working out a settlement, can get some kind of benefit. It gives finality to the part of the dispute which is settled through mediation. It only requires a mediator. Of course, there are certain issues of ethics involved, like candor, disclosure. The parties should know what they are agreeing to. Mediation cannot be forced, but of course, the parties to the mediation can be persuaded. The confidentiality issue is there. But nowadays, with technological advances, even in case of online mediation or online adjudication, confidentiality can, if required, be maintained, and necessary steps can be taken in law for breach of confidentiality. As I mentioned a little while ago, it is predicted that the number of cases, the courts are already overwhelmed, at least in India, and the number of cases are going to increase because there will be cases arising out of termination of employment. There will be cases arising out of breaches of contract, maybe not deliberate, but because of the situation. There will be cases arising out of business houses unable to pay their dues because the business houses have not been able to carry on business profitably during the unusual times. There could be family disputes, and the regular kind of litigation would always be there. Now, if those disputes which can be settled through mediation, including commercial disputes, civil disputes, of course, even family disputes, which can be settled through mediation, if these are settled through mediation, then the courts can obviously devote their time to issues of constitutional importance, to the more serious criminal cases and other cases which cannot be settled by mediation. Some criminal cases which are compoundable can be settled by mediation, but not those cases
All.
which are in the category of, state versus the accused. These are crimes against society. Similarly, there are important socio-economic crimes. These cannot be settled by mediation. So the courts can devote more time to the disposal of the more complicated cases. I am very hopeful about the future of mediation. And I think every dark cloud has a silver lining. What the COVID-19 has done is it has fast forwarded the popularity of online mediation, I would say by 5 years, 10 years. Because out of necessity, people have been compelled to accept online adjudication and online mediation. And the more of online adjudication, online mediation, people will come to accept it, because people will realize that this is less expensive, more convenient. Sitting in Delhi, you can do a case in Singapore, you can do a case in Madras, you can do a case in London without having to travel to 3 different cases. And the dispute, once settled, would give some kind of relief to both the parties. In adjudication, the legal rights assume importance. In mediation, I think fairness and substantial justice assumes more importance. But there are 2 things which are important to make mediation really successful. One is the personal commitment and capability of the mediator. The mediator should have persuasive qualities, should conform to the ethical values which mediators are expected to possess. And the courts also should encourage settlement by mediation. I will end with a very small example. When I was heading the West Bengal Legal Services Authority as a judge of Calcutta High Court, I found that the response to mediation was very poor. The lawyers would not agree to have their disputes referred to mediation. So I used to try and sensitize these lawyers. So one day they came and told me that it is so difficult to get a matter listed. And then when it is about to be called on, or when it gets called on, the matter is referred to mediation. If mediation succeeds, good. But just in case mediation does not succeed, then what happens? The case goes down again. I kept that in mind. So every time I used to refer a case to mediation, I also used to direct that the case should retain its position in the list. That it should not go out of the list in case it came back. You know, I also used to fix a date for hearing. We followed the same practice even in Madras High Court, because I remember when I was in Madras High Court, sometimes the lawyers used to have similar apprehensions that if now the case is sent to mediation, the case may not appear in the list in case mediation fails. So we used to ensure that this did not happen. But today, be it the litigant or the lawyer, will cooperate with mediation, with online mediation, because it is in everyone's interest. I think I have overshot my time. I can only say that I am very hopeful about the success of mediation even in this country. Thank you very much.
Thank you very much, Honorable Justice Indira Banerjee, Judge, Supreme Court of India. And Madam, after hearing you, we all are very, very positive that steps should be taken by the mediation centers across the board, especially in the post-COVID era, to establish technology-driven mediation, that is ODR mechanism, acceptable not to the masses only, the litigants and the litigators also. Thank you very much. I will hand over the proceedings to Asha Nair now.
Thanks, Nandini. Good evening, ladies and gentlemen. Before I propose a vote of thanks, I have the great honor to introduce Right Honorable Baroness Patricia Scotland, Secretary General Commonwealth. She has witnessed today's proceedings and would like to address us on this occasion. We welcome you, ma'am. I now request Rahul to please play the video shared by the Baroness. Rahul, it's not audible.
To perform that role well. And I would like to take this opportunity Good afternoon or good evening, everyone. I'm so pleased to be able to join you, albeit virtually. In William Shakespeare's Henry VI, Part 2, Act 4, Scene 2, he made clear that in order for anarchy to prevail, lawyers who uphold the rule of law and justice for all have to be expunged. So, since time immemorial, lawyers have always stood in the gap in order to be the bridge between those who wield power and those who are subjected to it. It takes courage, skill, integrity, and dedication to perform that role well. And I would like to take this opportunity to commend the Commonwealth Lawyers Association for always having the courage to stand in that gap. And so I am delighted to join you today, not just as your Secretary General, but also as a Commonwealth lawyer. The COVID-19 pandemic has significantly changed the way in which we live our lives and form our livelihoods. The world is challenged by economic, climatic, and political changes. We have lost about a third of the global economy, which means in the developing world, they have been deprived of $250 billion. This will have the greatest impact on the most vulnerable in our society, giving rise to real hardship for those least able to withstand it, and whose rights are most easily infringed, potentially losing many of the hard-won developmental gains of the last generation. The legal world has not been left untouched by this devastating pandemic. The rule of law has never been more needed, and the resolution of the multiplicity of legal challenges has presented us all with the need to look at new ways of finding just and equitable settlements, and has forced us to rediscover some older but potentially better ways of delivering justice, ways which leave fewer people behind. Mediation means fairness, sincerity, frankness, and honor. In a world where lawyers are called to be the oil that lubricates the relationships in our society, and where many lawyers are giving their lives to this cause, it is painful if a lawyer fails to live up to this honorable task. And this association is a bulwark which remains so needed in these tumultuous times, giving strength and courage to lawyers throughout the Commonwealth. The function of the judiciary is to adjudicate justice in a dispute. However, not all disagreements are supposed to be adjudicated by the state machinery. There are traditional means of adjudication that common law never took into consideration, and these mechanisms must be rediscovered. They are human, effective, cheap, and accessible. Only unresolvable disputes should be left to the state. This is where mediation comes in. Mediation is an efficient, sustainable, and cost-effective dispute resolution mechanism. I hope this gathering will encourage you to make mediation available and accessible to all who need to resolve their disagreements without destroying their commercial, familiar, or personal relationships. I hope from this gathering you will be encouraged to promote mediators through training and education, helping communities manage disputes in the public interest and facilitate the expansion and adoption of mediation as an alternative dispute resolution mechanism. Law is my profession, and justice is the end which law should serve. Mediation is my passion, for mediation goes beyond justice to ensure fairness, friendship, and kindness. These are perhaps the three most forgotten concepts in today's world. So I thank all of you who participated and are continuing to participate not only in this conference, but in promoting and exploring the benefits of mediation. I wish you well.
A pleasant evening to our valued Honorable Chief Guest, Justice Indira Banerjee and Honorable Justice Hema Kohli, and to our valued invited guests, the organizing committee, my dear friends and mediators, and everyone present here for this international webinar on post-COVID mediation, charting the path of the future. It's an honor and privilege to have been asked to propose a vote of thanks on this occasion. Ladies and gentlemen, this has been the second in series of webinars on the subject after completing a resounding success in the first series. Today's topic, resolving instead of adjudicating, is an important message to the society we live in, as I personally feel that we are one world and it is only a matter of reaching out, connecting, and getting enriched through each other. Post-COVID has given us this opportunity to take mediation to a new level with the help of technology. After listening to our esteemed speakers, one important aspect crosses our mind, that mediation has entered every sphere of life and law, be it personal or commercial. It has crossed boundaries. I, on behalf of the Supreme Court India mediators and the entire fraternity of the mediators, first of all, would like to extend my most sincere thanks to the Almighty God for making today's event a resounding success. With a deep sense of gratitude, I acknowledge the contribution of those who worked really hard to make this international webinar happen. I would like to extend my sincere appreciation and gratitude to our chief guests, Justice Indira Banerjee and Justice Hima Kohli, who spared their valuable time from their busy schedule to grace this occasion. Today, we had an opportunity to hear your thoughts, and this will surely add value and encourage us in our future events. Your thoughts have enriched as well as enlightened our minds and have shown us a new and clear path ahead. We are all inspired and highly motivated by your insights and great thoughts. Thank you. My sincere gratitude to all the speakers for sharing your important work and also enriching us with your experiences, findings through research work, and opinions today, which will additionally help us in taking mediation to a new level of understanding and interest. Thank you, Naja, for giving us your insights into the Singapore Convention 2019. And I must mention our deep sense of appreciation for your inputs on cross-cultural aspects of mediation. And I love the phrase she used, flowering of mediation culture and robust regulation. Let me tell you, ladies and gentlemen, that Naja has worked in more than 30 countries across the world, and that's truly international. Then we heard another wonderful speaker, Gunavati Subramaniam, who was part of the working team when the legislation in mediation was being drafted in Malaysia. She demonstrated in her presentation the drawbacks in their legislation. Thank you, Gunavati, for sharing it with us. It would truly help us, other countries who are in the process of drafting such legislation in mediation. Further, you also gave a thorough analysis of your country's legislation, pre-COVID and post-COVID, and its impact. We are very grateful for sharing your experiences with us, which would help in overcoming the hitches one may face in preparing the legislative framework in mediation. Your contribution is much appreciated. Further, I express my gratitude to Justice Joyce Aluk for sharing her vast experiences with regard to mediation at workplace. And I must say it's very important, since now the workforce also consists of a good proportion of women in all fields. It is also necessary to note that the workforce spends as much as 12 to 13 hours or even more than that at their workplace. Justice Joyce spoke about the power imbalance between the employee and the employer and the techniques used in workplace mediation. The need of the hour is to solve many disputes through mediation, which will bring in bonhomie, harmony and coexistence among the workers and the employers, resulting in productivity. Thank you so much. Our sincere thanks to Rebecca for giving an excellent coverage to commercial mediations. Her inputs in this global era of business activities would ease many of the tensions and stress related to work if mediation is opted as a first-hand tool to solve disputes. Thank you, Rebecca. Your presentation was very eagerly awaited by all of us, since I feel through my experiences as a mediator that the commercial mediation is still to be accepted largely by the business community as a concept for alternate dispute resolution. I may be wrong, and this is largely my personal impression. We would be more than happy that this concept of commercial mediation should be shared with the industries by regular seminars and discussions to take it to the next level. I liked what Rebecca said, golden age of mediation. Thanks so much, Rebecca, for your contributions. I'm also very grateful to Bertha Cooper for her interesting presentation with regard to women dominating the bar in the Bahamas and the Caribbean jurisdiction generally. I agree with you in toto, Bertha, and that more or less women have it in their genes. The characteristics of patience, listening capacity, less aggression, tolerance, and also the capability of sternness if the need so arises, which is a good combination to becoming a good mediator. My personal input here is a mediation team with an equal balance of both genders. We look forward to many more discussions and interactive sessions with our panelists in the near future. Well, ladies and gentlemen, an event like this cannot happen overnight. The planning and effort starts weeks ago. We have been fortunate enough to be backed by a passionate team who have been very proactive, motivated, and dedicated colleagues of the Supreme Court Mediation Center. And in this regard, I would like to mention senior advocates, Mr. Rakesh Khanna, Mr. Rajiv Datta, Mr. Jitendra Sharma. And I would specially mention Advocate Santana Krishnan, who is the past president of the Commonwealth Lawyers Association and has contributed immensely for this webinar. I'm short of words for their involvement and their willingness to take on the completion of tasks beyond their comfort zone. I'm immensely thankful to Ms. Abha Sharma for introducing our esteemed guests and Ms. Nandini Gore for moderating the session and for her efforts towards anchoring of today's program. I also extend thanks to the technical team for their enormous cooperation to make this webinar a successful event. And in this regard, I have to make a special mention of Rahul, who is a law student and has been a great help in coordinating with the technical team and the organizing committee. Further, this webinar would not have been possible without the support of Supreme Court Mediation Center, Supreme Court Mediators, the Commonwealth Lawyers Association, and the Youth Bar Association. I thank the participants for their active participation during the weekend. To conclude, Honorable Chief Guests, ladies and gentlemen, once again, I would like to state that we are all most grateful to all speakers. We thank you for being with us this evening. It's been a great pleasure. Let me remind you once again that this is a continuing series and we look forward to the third in the series of webinars and would love to welcome you all. Thank you so much. Over to you, Nandini.
Thank you.
Thank you very much.
Thank you all. Thank you, everybody. Rahul? Rahul?